Um, we are at 8:20, so the City Council started our meeting at 5, so we will take a break at 9 o'clock for 10-15 minutes. But for now, we're going to jump right in for our study session. So at this time, we will begin our study session. Tonight's session is to receive information on state housing laws, including California Senate Bill 9, Senate Bill 330, the Housing Accountability Act's Builder's Remedy, and other relevant laws and regulations. We will start with a presentation from our staff. Following the presentation, council members will ask clarifying questions. After that, I will open the public comment period. Once public comments conclude, I will ask our staff and the city attorney to address general questions raised during the public comments period. Please note that we will not and cannot address specific development project during this session. So staff, please begin your presentation when you're ready.
Okay. Good evening, Mayor Zhao, Vice Mayor Aftab, members of the council, and residents of the City of Saratoga. My name is Brian Swanson, and I serve as the Community Development Director for the beautiful City of Saratoga. The study session item this evening will focus on state housing land use laws. The presentation will be led by myself and Richard Taylor, the city's attorney. Prior to starting the presentation, I would like to mention that, as Mayor Zhao indicated, there will be no discussion on specific projects, but rather an overview of the laws. Finally, I would like to extend gratitude to the staff of the Community Development Department for their dedication on managing and enforcing these new state laws that are being crafted quickly at the state legislature. Special thanks to the amazing residents of the City of Saratoga, which have taken time to meet with me on many occasions in understanding these new laws, and to Richard Taylor and his team on always being available to answer any questions staff has on these laws that are coming quickly to us. The overview tonight on relevant state laws will include the Housing Accountability Act, otherwise known as the HAA, and the Builder's Remedy, SB 330 and preliminary applications, new Builder's Remedy project reviews, litigation update, and at this point I'd like to turn it over to Richard.
Thank you, Brian. Madam Mayor, members of the council. We have a lot to talk about this evening, and as much as we are going to say, I want to say this is really the tip of the iceberg, and I think iceberg is an appropriate metaphor for what we are having to navigate with the body of housing laws. I was at a legal education thing, and somebody said that the legislature has passed over 250 bills regarding housing and local government in recent years. So we're going to be talking about what is most pressing in Saratoga right now. Things will change over time, but right now the Builder's Remedy projects are what we are facing the most of. So the background for the Builder's Remedy starts with the Housing Accountability Act. And this is a law that's been on the book for a long time, and it basically works to limit the ability of local governments to deny development projects. And you've encountered it when you have projects, and I say because a project has 2 units, you can only deny it based on an objective standard. You can't deny it based on a subjective standard. But there's a separate provision of the law designed to protect projects that have some affordable component. And what it says is that if a project is 20% affordable or 100% affordable to moderate income, then there are only 5 reasons that the city can use to deny that project. And the main reason, the most common reason that is used, is that a project is inconsistent with the general plan or the zoning. And that is common. When I was in law school, they taught us that the general plan and zoning are the constitution for development in the city. So that's fundamental. If a project isn't consistent with the general plan or zoning, obviously it can't be approved. But the Housing Accountability Act has an exception, and it says that that a project does not have to be consistent with the general plan or zoning if a city doesn't have a valid housing element. It's as if the legislature thought, and again, this was years ago, as if the legislature thought, wow, if there isn't a valid housing element, we're in an emergency and we need to say anything goes to begin getting the housing. And to also create an incentive to local governments to get their housing elements done. But again, this law was passed a long time ago, and it sat and was rarely used. So this is what we call the builder's remedy. The word builder's remedy doesn't appear anywhere in the statute. It will on January 1st, 2025. I'll talk about that. But the bottom line is that if a city doesn't have a housing element that complies with the law, then projects don't need to comply with the general plan or zoning. And the general plan or zoning, just to set, is what sets the maximum height, it's what sets the maximum density, it's what sets the setbacks. All these things that are very important to us as we plan for development. And it also includes many other standards. And all those are things that we cannot deny a project based on a project's failure to comply. There are other authorized grounds that you can deny a project. One of them is if we have a valid housing element and we've met our RENA. So if we have a housing element and we've built the 1,700 units or so that are in our RENA, we can deny the projects. If that isn't likely to happen in the near future. If there's a specific adverse impact to public health and safety per a formal objective standard. So it's not enough for us to say, wow, this project seems like it could have an adverse impact on public health. We have to be able to say, oh, here's a standard in the building code, here's a standard in our zoning code, here's a standard in state law, and it doesn't meet that standard, and it's an objective standard. And an objective standard is one that anybody can look at it and figure out what it means. We can deny a project if the denial is, or impose a condition, if the denial is needed to comply with a state or federal law. And we can deny a project if it's proposed on agricultural land that has open space or other agricultural land on two sides of it, or if, again, based on objective standards, there's not adequate water or sewer infrastructure. So the law does contemplate some basic reasons, but it applies them very narrowly. Now, the Housing Accountability Act does say that CEQA applies. It protects CEQA. It says nothing in this law means that you don't have to comply with CEQA. So we have to do environmental review. These projects have to undergo environmental review. We have to look at the impacts for projects that aren't exempt, and we have to identify mitigation measures. We have to look at alternatives. To the point of the comments earlier, we have to look at cumulative impacts. So in the environmental review for the Builder's Remedy projects, there will be a cumulative impacts analysis for a range of impacts, including the climate impacts and the traffic impacts that we were talking about. There is a challenge, though, because we are not allowed to deny the project or impose conditions on the project that would make it infeasible. So if an environmental review says, oh, there's a significant impact, and we say, oh, well, we can mitigate that impact by reducing the density by 10 units an acre, that would make the project infeasible. We're not allowed to do that. We have to find ways to mitigate impacts that are not going to mess with the feasibility of the project, and that's going to be a challenge in the environmental review. And it may be that there are some impacts that there simply is no way to do that. The law also shifts the burden of proof. Usually, in almost any circumstance, if you want to sue somebody, you go to court, and the burden is on the person doing the lawsuit, the plaintiff. The burden is on the plaintiff to show the court why the person that's being sued or the entity that's being sued has done something wrong. I tripped and fell in front of a store. Well, I have to prove that the store did something negligent that made me trip and fall. This law changes the burden of proof. If a city is sued for violating the Housing Accountability Act, the burden of proof is on the city to show that it did nothing to violate the law. So it shifts the burden of proof if we deny for any reason that is improper under the law. And it changes the standard of review. If I trip and fall in front of a store, I have to show that it's more likely than not that that it happened, or that in our standard lawsuits, is there substantial evidence? And typically substantial evidence is, well, two people can disagree, but both stories are reasonable, therefore I'm going to accept the story of the government. That's the traditional standard of review for local government decisions. This law says that the city has to show that its actions were legal by a preponderance of the evidence. That's a very high standard of review. We have to say, look, looking at the bulk of the evidence shows that we did everything right. So that's the background in the Housing Accountability Act. Finally, the law also provides that the city is liable to pay the plaintiff's attorney's fees if there's a lawsuit and the city loses. So a few years ago in San Mateo County, they denied a project. That denial was challenged as being improper under the Housing Accountability Act, according to press reports. City of San Mateo settled that for $450,000, paying the attorney's fees for the other side as part of the settlement. That's in addition to the fees that the city had to pay its attorneys and consultants in doing the work. So, Housing Accountability Act limits our discretion in denying projects significantly for projects that come in when we don't have a housing element. And then it allows us to use CEQA, but it shifts the burden of proof, sets a strict standard of review, and subjects us to attorney's fees. The Housing Accountability Act has to be looked at in conjunction with SB 330, which was adopted in 2019, many years after the Housing Accountability Act and the Builder's Remedy provisions that I've mentioned were put into place. And SB 330 was adopted in 2019, and it was called the Housing Crisis Act of 2019, and it covers all sorts of issues. And we thought, wow, this is such a significant imposition on the state coming in and managing the local approval process. And we thought that was going to be it, but it turned out it was the beginning of a series of laws. But the thing that's important for the Builder's Remedy is this law introduced the concept of a preliminary application. And the idea of a preliminary application is that what would happen before is a developer would go through, do work, turn in an application, which can be an expensive process to pull together an application with all the plans and all the information that the city wants. The developer would turn that in, and the city would say, whoa, we never had this in mind, and the city would work to change its general plan or zoning so that that project couldn't move forward. And by the time the project was considered, the zoning had changed and the project couldn't move forward. This law was designed to stop cities from doing that. This law says if you submit a preliminary application, which is a very simple application, that you then are what we call vested. You vest the right to have your project considered on the rules in effect when you submitted your preliminary application. So the idea was that cities can't change the rules. Well, people said, well, the rules on the day I submit my preliminary application are that the Builder's Remedy applies. Therefore, when I submit my application and the Builder's Remedy applies, I lock in the protections of the Builder's Remedy for going forward. So that is the argument that people have made, and the courts have confirmed, and the legislature has just confirmed that that's what they think SB 330 was intended to do. So that's an important thing to understand. Finally, part of the reason why we are talking about how we can't talk about specific projects tonight is SB 330 introduced what we call the 5-hearing rule. We are not allowed to make a project applicant come to more than 5 hearings about their project. And hearing, I think of hearing as, oh, we've sent out a notice. But there are a lot of arguments that SB 330's use of the word hearing applies it to any meeting. So we want to be very careful, and we want to make sure that people don't think, that the applicants don't think that we're making them come to more than 5 hearings. So pulling this all together, Builder's Remedy, why now? We have the Housing Accountability Act rules. We have higher RENA numbers than we've ever experienced before, which made preparing the housing element a lot harder. Saratoga has the last 3 housing elements that I was a part of all got done on time. It was no problem. There were hard decisions to be made. They were not easy, but we got them done. But here, with the higher RENA numbers, it was a much more complicated planning process. It takes time, and this has been the case in every jurisdiction in the state. And there are new standards for housing elements. The level of detail in the policies that the state is looking for and the level of state review of those policies is much more exacting. So that means it takes longer, so there is a longer period of time. And I've heard people say that part of it is there was a consultant shortage. There are only so many planning consultants, and with the new housing laws and the new focus, they were, and I can attest from working with them here in Saratoga and in other clients of ours, they were working lots of overtime to get the housing elements for their various clients done. So then we have the preliminary application process, and then we also have something that we didn't have 10 years ago. We have housing advocacy groups that are spending a lot of time thinking about these laws, writing articles, writing op-eds, going out, educating developers, educating property owners about their options and how they can use these laws. And so that is an opportunity and for people to come make these applications. So I think that's why we are seeing builder's remedy in a way that we really hadn't before. So we have in Saratoga the 22 builder's remedy projects that have been filed. We now have a certified housing element by the state. Nobody can submit a builder's remedy project today. We have a defined universe of those projects. But the state legislature has just adopted new legislation amending the builder's remedy law. And they've crafted that legislation in such a way that anybody who has a current builder's remedy application can transform that application to a new builder's remedy application. We'll have to see how that plays out in Saratoga because, well, let me just walk through what the legislation does. AB 1886 says it's the legislature's intent that the only way for a housing element to be valid is for a court or the Department of Housing and Community Development to have said that it's valid. So this concept of self-certification in Saratoga, you adopted a housing element and you adopted findings saying, here's why we believe this complies with state law. The state legislature has said they don't care what you think. It only matters what HCD thinks. And the AB 1886 also says that a preliminary application locks in the builder's remedy. And they say this isn't anything new. They say this is what the law has always meant. Now, a court might not agree with that, but that's what the legislature has said. That's what HCD said about the laws all the time going forward. So now AB 1893 is what really makes substantive changes to the law going forward. Right now, right now meaning today in 2024 until January 1, 2025, you can submit anything. There is no relationship to the general plan at all. So one of the provisions of AB 1893 is that they set density limits so that there is an upper limit on what can be applied for. In Saratoga, I'm not sure how meaningful that is. The upper limit is, it starts at 45 units to the acre, and then for areas such as Saratoga, which are called high resource, because we have good schools, we have good infrastructure, the state has a whole modeling process, and they've decided what parts of the state are high resource. If you're a high resource area, you add 35 units to the acre to that 45. So the base density is 80 units to the acre. The most dense, the applications that we have, the most dense is 54. So, and people could have applied for whatever they wanted. So presumably people aren't going to want to come in and take advantage of it, but we don't know. The legislature has given people the opportunity to open that door. The legislation is, it clarifies something that we always believed was the case about our ability to apply our objective standards as long as we don't make a project infeasible. But it makes that a little bit more clear than it had been. But it also talks about what makes a project feasible, and there is an argument that the new law says a project is feasible if a developer says it's feasible based on what they plan. That is a little bit of an overstatement, and it's something that we're going to be grappling with, but that's what the legislature has done. Now, the way this is all framed is, well, we set density limits, and so because we've taken away from developers the ability to apply for any density they want, we've limited them to 80 units per acre, we aren't going to require them to produce as much affordable housing. So remember my first slide talked about you get the builder's remedy if you have 20% affordable. And all the projects we have 20% affordable. Now you can have 13% affordable or even less if it's affordable to lower income categories. And the law adds new provisions saying that if a city engages in conduct that is an unnecessary delay or is harassment of the process, that is tantamount to a denial and allows the developer to bring a lawsuit forcing the city to prove with a preponderance of evidence that its conduct is not harassment or an improper delay. So those are the highlights. Again, this legislation is very complicated. It was recently adopted. We're going to be having to figure out all the details of what it means as we get specific projects, but that's the overview of where we are on the builder's remedy. On a parallel track with the builder's remedy, for a few years now, we've been working to implement the state's Senate Bill 9. And that goes back to 2021. And this is the law that requires us to ministerially approve. That means it's a checklist. It's not anything that needs any discretion issued. There's no subjective standards of lot splits and construction of up to 2 primary dwelling on any single family zone property. So we had a zoning ordinance. We say, here's a single family zone site. And the state of California said, throughout the state of California, any land that is designated as single family actually can have 2 units on it. And each of those units can have an ADU associated with it. So those projects do have to comply with the general plan and zoning, but there's no CEQA review. And in 2024, the legislature amended the law to facilitate development. So we are going to be bringing to the council code changes that we are required to make to make the SB 9 process a little bit easier for landowners. So I just want to emphasize, I've talked about SB 9. There are all kinds of other laws facilitating development of commercial properties into housing, laws facilitating development of certain vacant lots into housing, but we would be here all night if we tried to go through all those. So I'm now going to, you've heard me talk a lot, so I'm going to turn it back to Brian, who's going to talk about what the city's process is in reviewing builder's remedy projects, so we can understand how that process works. And then when he's through, I'll talk about where things stand in lawsuits surrounding builder's remedy projects.
Thank you, Richard. So as Richard stated earlier in the presentation, we talked about preliminary application of a builder's remedy project. You can go on the internet and search for the preliminary application. It's very easy to find. Essentially, when a developer or an applicant submits a preliminary application, they vest their development rights upon the receipt and the date of that application that's submitted to the city. While the city is not required to, staff provides a notice of incomplete within 30 days of receiving the preliminary application. That's our way to add a note to file that we received the application, but it's incomplete. A formal application, so a formal application is an application that requires complete drawings, civil engineering, architecture, site plan, landscape plan, That's required to be submitted within 180 days of the initial date of the preliminary application. So the developer has 180 days to submit their formal application to the city. The preliminary application, if you look at the application, it's very basic. Site plans required to be submitted, pretty much filling out the form. So it's not meant to be very arduous, but the 180 days is where the applicant has to really spend a considerable amount of time to submit a application that geotechnical, engineering, architecture. So once the application is received within 180 days, the plans are routed to the appropriate reviewing internal departments such as Public Works and County Fire. So everyone has to review the submittal that we get as a formal application. Staff only has 30 calendar days to review the formal submittal to determine if the application is deemed complete. So you might ask, what does that mean? What does deemed complete mean? A project is only deemed complete if all of the items on the checklist for development for the City of Saratoga are met. So you can submit a formal application, might not meet all of you might have all the different studies, the plans, but it might be missing items on their checklist. That project would be deemed incomplete. Our review goes back to them within 30 days, and the applicant has 90 days to resubmit after our review of the complete or incomplete. If the project is deemed complete, the consistency review begins. While the project is not consistent with the general plan or zoning ordinance, the applicant must meet the consistent review requirements from their underlying departments or outside our agencies, or indicate why they cannot meet the consistency review requirements. The process also begins the initial development of conditions of approval for the project. A project must also meet the California Environmental Quality Act, known as CEQA. The project must be analyzed by a CEQA consultant to determine impacts, mitigation measures of those impacts. And those impacts and mitigation measures are captured through a document entitled the Environmental Impact Report, or an EIR. The project must still follow the typical development process and appear before the Planning Commission. If necessary, City Council review. However, as Richard stated, a maximum of 5 hearings may be put on a builder's remedy application seeking development approval. That concludes my section on that, Richard.
Thank you, Brian. Yeah. So the builder's remedy, we are working with, there are no published decisions about the builder's remedy. There are no published decisions, and a published decision is a decision issued by a court of appeal that the Court of Appeal has said, we want this decision to be published. And once it's published, then people can look at that and rely on it for, oh, this is what the courts say this law means. All we have is a few lawsuits in Southern California. So Southern California, their RENA deadline was earlier than the Bay Area's. So that's where the Builder's Remedy project started. That's where a lot of these legal fights have played out. That's where a lot of what we see in 1866 and 1893 comes from debates that they've been having in Southern California. So we have no published decisions. They are all cases in which developers or housing advocacy groups sued the city for either denying a project or saying they were refusing to process a project under the Builder's Remedy. And the cities have not, the cities have won some sub-arguments, but no city has won everything. And the Attorney General has intervened in many of these cases on behalf of the housing advocacy groups or the developer. HCD, the Department of Housing and Community Development, submits declarations saying why they think the city's conduct is wrong. So it has been an uphill battle for the cities in terms of facing the Attorney General, the court. If you're a Superior Court judge, you've got all kinds of cases before you. You've got 2 lawyers telling you, I'm right, no, I'm right. And then you have the state attorney general coming in and saying, no, that one, they're right. It's something that, is a difficult thing to stand up to. But that's what the Court of Appeal is there for. And some of these cases are up on appeal, and so we may get some decisions holding differently. The decisions have found, so some cities were saying, we're not going to process your builder's remedy application unless you formally apply for a general plan amendment or zoning. And they've said, no, the builder's remedy says you don't have to be consistent with the general plan or zoning. Therefore, that's an effective denial. And they found that a preliminary application does lock in the builder's remedy. So that the builder's remedy is available until HCD has certified the housing element, as the legislature has now said in 1866. This is against a backdrop of the city of Huntington Beach and the city of Redondo Beach have made it a city mission to fight the state and to sue the state over these laws at every opportunity they can. And they succeeded in a coalition of charter cities, sued the state over SB 9, and they said, so charter cities, in theory, again, when I graduated from law school, charter cities had a lot of power, and the idea was that the state can't tell charter cities what to do unless the state has a really, really good reason. Well, in the time that I've been a lawyer, virtually every decision has said, oh, well, the state, they have a good reason. Yeah, that's a good reason. Yeah, the state thought that was a good idea. But in this SB 9 case, the charter cities said, look, the state said they were doing SB 9 to promote affordable housing. But SB 9 doesn't say a word about affordable housing. Therefore, how can they say this is so important that they can usurp our charter city authority by doing it? And the trial court agreed. Now that case has been appealed, and SB 450, the legislation that is forcing us to make SB 9 projects even easier, also changes the findings that the legislature makes and states explicitly what is implicit in everything. The legislature's policy view is one of supply and demand, that the more housing units that are developed, even if they are market rate units, in the long run, having more housing units is going to make housing affordable for everyone. And that is the philosophy behind this, and that's what they've stated. And so that is something that the courts will have to look at in doing it. But so when you read the newspapers, everything is about the housing crisis. And judges, their job is to apply the law, but they're also, fortunately, human like us, and they take that into account, and they read the newspapers. And the, by far, dominant narrative is that we have a housing crisis. And so when they are confronted with a lawsuit, and especially with laws that direct them to defer and err on the side of promoting housing, that seems to be where people are going. So, but again, there are good creative legal arguments that people can be bringing to the Court of Appeal, and so we may be getting better guidance in the months and years ahead. So that concludes our presentation.
Wow, that's a lot of education on all the state laws and the Housing Accountabilities Act. At this time, it's almost 9 o'clock. Since we start our meeting at 5 today, so I would like to take a break for 10 minutes. Let's see, I don't have what time is that exactly? I can't. 8:54. Let's come back 9:10. You want 9:05? Okay. So we'll take a 10 minutes break. We'll be back at 9:05 to resume questions and public comment. All right. Thank you. please. Maybe we'll give another minute. We're missing one council member. All right, he's coming up here. Jack, can you please join us on the stage, on the dais? All right. Okay, Britt, are we back online? All right. Once again, I'd like to thank Brian and Richard for their detailed presentation. Now, I'd like to kind of, first ask our council, does any council member have any clarifying questions for the staff? Yes, Council Member Walia.
Thank you, Mayor Zhao. Richard and Brian, that is a very impressive report. There is a lot of information, a lot of laws that you have put together, how they fit together, and impact the projects that you're dealing with, the 22 projects here in Saratoga. So thank you so much for that, both of you, Richard and Brian, and Matt, because I know you have all been working on this the last, quite some time. So I have a few clarifying questions. Brian, you have been talking to residents for over a year since we got the first Builders Remedy project, and I know they are also reaching out to council members, so we're trying to convey as much information as we possibly can. But to have this repository of information together here is very, very helpful. Richard, this question is more for you. What I heard when you were presenting, you said about the Builders Remedy that this law was written about 40 years ago, and the intent was there's an emergency because of the lack of housing or something like that. I'm just paraphrasing you kind of. A law written 40 years ago combined with newer laws doesn't quite perhaps, that's the sense I am getting from residents, that something is not quite working well together. The intent, the situation at that time versus what is there now. If you want to comment on that, just very generally.
Well, I think that is certainly what that is what the jurisdictions in Southern California argued. They argued this can't be what it means. And we've certified our housing element ourselves. That should be good enough. We have adopted our housing element, and so now that we've adopted the housing element, the builder's remedy should no longer apply. It shouldn't be able to vest. But the courts, so I can understand that feeling. The courts down there didn't agree, and now the legislature has said in AB 1866, no, this is what we meant all along. Now, the courts can go look and re-examine, and they are not required to abide by what the legislature said, but I think the legislature is still very much is going to weigh strongly in the minds of a judge.
Okay, thank you. The other thing you mentioned is CEQA, and you mentioned a couple of things that will be studied under CEQA. I'm familiar with it. Everyone here is familiar with it. But for a project, a Builder's Remedy project that you will be asking for CEQA, California Environmental Quality Act, do you want to mention a few categories? Because I know there's a lot of question from the public concern about different things.
Sure.
What gets studied?
So traffic, noise, impact to, there could be design, so architectural design, fish, wildlife, water, pedestrian access. So a project that impacts, we have to study a project. Any project's going to have an impact on the environment, on property, off-site, on-site. And so a CEQA document studies those impacts, and they create mitigation measures to offset the impacts of that development.
There was a reference earlier this evening to the emissions from traffic. Is that something that is included in
Yeah,
CEQA?
so greenhouse gas emissions, yes, that's
Yeah.
one of the areas of study with the CEQA document.
Yeah, and also a lot of questions on concerns from fire, wildfire in the hills. I've
Yes.
heard that a lot. You have heard that a
So,
lot.
Yeah, understanding evacuation routes for projects that could be in the very high fire severity zones. That's important to understand in a CEQA document.
Okay, and one of the questions and also a remark earlier this evening was how will the CEQA document address the cumulative impacts of those things?
So these CEQA documents have to study the effects of all of these projects combined when they go through, these are going through the process.
You
so
mentioned,
it's a cumulative effect.
thank you.
Yeah,
So you mentioned, or what I heard was that the applications, the applicants with the prelim application, they have a vested interest, but with the newer laws, especially 1893, they can change the scope. So if they can change the scope, there are 22 builder's remedy applications. The first one to come up with an EIR work, and then the 20th one, which can continue to change the scope. How do we know what's the cumulative impact? What's the scale of that, let's say, the 20th? Or is that, I think Richard has the answer.
Well, I have an answer. That we are obligated under CEQA to look at reasonably foreseeable impacts. So when we do the first cumulative impact analysis, we will look at the reasonably foreseeable impacts at that time. And that will be based on the applications that we have. We can't conjecture, oh, somebody might do this or somebody might do that. Then when we have information to indicate that it's reasonably foreseeable that something else will happen, then we would look at that. So we have to start with what we are, and CEQA does have provisions for when there are changed circumstances. So if between the time we release a draft EIR and when the final EIR comes out and we're about to make a decision and we learn that 10 of the projects have tripled in size, and that increase itself could have a significant impact, then that's the kind of thing we might need to go back and relook at things.
Thank you. That's very helpful. I have two other questions. One is about the specific question about the process, as much as we can in a general manner. County fire, because a lot of questions have come on that, and Brian, you're addressing that. So what's the process from a process perspective?
So every time we receive a resubmittal from an applicant, the clock starts on our end to get the resubmittals back to all of the different agencies. And so County Fire has 30 days to respond to submittals that are received. Once a resubmittal is received to the department, they are on the 30-day clock, just like Public Works, Community Development, San Jose Water. Everyone has to get back their comments within 30 calendar days.
And then your department has to convey all of those comments from different departments, because you're working
Correct.
in parallel with
Yeah.
all of them. The burden is on your department to respond to the applicant within 30 days. Is
Right.
that?
Yeah, so we are, the Community Development Department is kind of like the collector. We take all these comments, and after we receive all the comments from the different agencies and the internal departments, we send them to the developer. We send, developer, here are all the responses. Your application is still incomplete. And the developer has more time then, the clock resets for the developer to resubmit, and that process can go back and forth for quite some time.
And that's what I was coming to. And that can go, there is no limit to the number of times, because they get 90 days, then back to you for 30 days.
Correct.
And there is no limit to how many times. They can continue to respond
Correct.
as many times as it takes.
Yep.
Okay. Just one clarification. I know a lot of work has gone into putting the information on the city website, and thank you to the team for doing that. You have also started an FAQ list there. So some of the comments and the questions we are picking up tonight, is it possible to add that as time permits? Because I know staff CDD is very busy because we are also at the same time implementing all that we need to do to stay on track with HCD regarding the housing element that has been certified, but there's work that continues on that. Matt, is that something that's reasonable to ask?
Yeah, we'll work on updating the FAQs if there's additional information that comes out of this evening's conversation.
Okay, thank you. Thank you so much. I'll stop there with my questions for now. Thank you so much, Mirza.
Thank you, Councilmember Walia.
Madam Mayor, if I may, I just want to clarify on the CEQA, just so that first we do that and we have a couple of environmental impact reports that are being prepared. It is not yet clear if every single project is going to have an environmental impact report and that level of detail. Some projects will be entitled to have a mitigated negative declaration. It's possible that there may be one or two projects that that CEQA says, oh, these are exempt from environmental review. So those decisions are going to have to be made project by project. And then I want to emphasize that while the legislature has put us in this position where we have to look hard and we have to identify all the significant and unavoidable impacts, and we have to propose mitigation measures, but we may not be able to require those mitigation measures because SB 9 doesn't allow it, because the builder's remedy does not allow us to impose mitigation that would make a project infeasible. So we have to find ways to mitigate impacts that will not undermine the feasibility of the project. So now that is different from if there is an objective standard that says no, that is a health and safety standard, then that is a basis that can be used to deny the project.
What's a health and safety standard, Richard? For example?
For example, a law saying that well water has to be can't exceed a particular level of contamination, and a project is relying on well water that exceeds that level of contamination.
Okay. Thank you so much for the additional information. Appreciate that.
Thank you. I know Vice Mayor Aftab.
I have a few questions about AB 1893. So I recognize that part of that adds clarity to density. When it comes to the application process, right? You submit a prelim application, then a formal application. You can sort of keep on resubmitting if things are incomplete. Is there any aspect of AB 1893 that would allow an applicant to modify their application to increase the number of units?
Yes. So under the law as it is today in 2024, you can only increase your application by 20%.
Okay.
Under your preliminary application. The legislature, in cleaning up the builder's remedy, has said that you can apply under the new builder's remedy law for anything consistent with that builder's remedy. So that 20% limit has gone away. Now, again, there was no limit in what people applied for. So presumably people went and looked at the market and thought about what would make their project feasible and proposed a project that made sense. So my hope is that there wouldn't be big increases for that because they could propose whatever. And now AB 1893 is a limit, but nobody proposed anything that came close to that limit. But the law does allow them to ignore the former 20% limit and come in with something bigger.
Okay. And then how are we doing? We have a very high volume of applications, right? Any other city I talk to, when they hear our number, they're kind of floored by how many we have. How are we doing from a response time perspective? I know we're sort of obligated to get back within 30 days, but if we are, we have the same staff that we did a year or two ago, but now we have significant more obligations for these applications. How is that affecting us, and is there any recourse for us on that, or any additional funding that we can get?
Yeah, so the department works as a team with the Builder's Remedy. It was a brand new project that came to the City of Saratoga Community Development Department. So we've been attacking it as a team since July of 2023. And some of that early work has helped come up with a streamlined process for us to be able to review and meet these deadlines. And so that what's important is that we meet the deadlines for the builder's remedy, and in collaboration with Richard's team, it's worked pretty well. We've been meeting the deadlines, but it is additional work that's come to the department. Yeah.
If I can add to that just a little bit. So I've been having conversations with Brian about the workload, and you're right, it's a significant workload, not only in the quantity of projects and number, but the size of projects. And I think it's impactful to the department, and they've done a stand-up job in delivering and making sure that they hit the deadlines, and that's extremely important. Our community development department is a cost recovery department, so they have fees that cover the cost of delivering the projects, and that includes the staff work that goes behind it. So theoretically, there is funding already built into the projects as they're delivered to pay for the costs associated with them. The challenge is that we're not always as nimble as you might be in the private sector to be able to flex in staffing to deliver projects. So we handle that in a couple of ways. One is we talk and we balance, and Brian does that work in managing with his team. The others, we use consultants to augment the work. And then the third is when we have a forecast for work that may last for a long period of time, we'll come to the council and we'll ask for assistance there. And that would look like a number of different things, but one of them could be a staff augmentation, additional staff to help deliver projects. And so that's part of the conversation that we'll bring to you over the next 6 months or so as we're identifying challenges. And there may be a request for more staff, there may not, depending. We may use consulting resources, but we want to have that fair conversation with the council on what the impacts are.
That makes, it's a pretty big challenge, because on the one hand, we're being asked to implement the housing element and then also do all of these, so that's a ton of work. And so last question on this, and this is just for the sake of clarity, so are there any additional fees that are being incurred by the city for these 22 projects? And so, for example, when it comes to the consultant that will draft an environmental review, is the applicant paying for that? Is the city incurring any costs there?
No, it's all applicant funded. So city staff time is being charged to the deposit account that the applicant has to provide. All CEQA work, so that's the consultant that's doing the CEQA document, is all applicant funded, but it's the city's is the lead agency. It's our document, the consultant reports to us, but the applicant pays for that. So, yeah.
Any other questions from the city council? No? All right. Just to follow up, I have a question on the CEQA. You mentioned if there's no mitigate measures to address all the problems, but city can still cannot say no.
Again, if we can impose conditions that don't make the project infeasible. So if there's a condition that we can set the project back a little bit more from a stream, and that's not going to make the costs so much or make the project get smaller, we can impose any condition that doesn't make the project infeasible. But if a condition would make the project infeasible, the builder's remedy says that we are not allowed to impose that.
Does that defeat the CEQA's requirement? You're supposed to...
It is in great tension with CEQA. CEQA says that we aren't supposed to approve projects with impacts that can be avoided through mitigation, but CEQA also says that you can adopt what are called findings of overriding considerations. And findings of overriding considerations, you can say, it's not feasible to impose this mitigation measure, and that would be because the builder's remedy law doesn't allow us to impose that mitigation measure.
Okay, all right.